Very good. So noted. Thank you. All right. Next up is, I think, Senator Morlock has a date of separation, another easy topic. Okay. This is file item 11 SB 1255.
Thank you, Madam Chair. Now that we're getting close to the dinner time and I'm Vice Chair, I'm happy to chip in for pizza for the members of the...
I hope that we won't be here that long. It will. All right. Good afternoon.
Thank you, colleagues. Senate Bill 1255 would amend the California Family Code to allow for a couple to be considered living separate and apart while still living under the same roof for purposes of establishing a date of separation as a precursor of divorce. Colleagues, life is very complex, and divorce does occur. When I was in the private sector, I would do an occasional seminar, and I would say that marriage was grand and divorce was 50 grand. Currently,
that's at least.
The numbers have changed a little. That was 25 years ago, but currently under the California Family Code, in order to establish the date of separation in anticipation of dividing property through divorce proceedings, a couple must demonstrate that they are living separate and apart, thus incurring the costs of maintaining two residences and reducing whatever reserves that may remain. In the recent case of Davis in 2015, the California Supreme Court ruled that in order to be living separate and apart, a couple must have separate residences. The court's ruling removes the ability for a divorcing couple to continue to co-parent their children in the same house during the divorce proceedings and still keep their finances separate. This forces at least one spouse to find and pay for alternative housing in order to establish a date of separation earlier than the final court order date, at a time when families are trying to closely monitor their spending and transition the family unit through a very trying time. Often one spouse cannot afford to move to a separate residence and can only afford such a move once a divorce is finalized. SB 1255 defines date of separation to mean the date that a complete and final break in the marital relationship has occurred, as evidenced by the spouse's expression of his or her intent to end the marriage and conduct that is consistent with that intent. SB 1255 directs a court to take into account all relevant evidence in determining the date of separation. Under this bill, living under the same roof is not a bar to establishing a date of separation, merely a factor to consider in the court's analysis. I've been amazed at how many have contacted me on this subject since my election. To date, we've been working with significant stakeholders. We have no opposition, and I have agreed to the amendment provided in your briefing, and I have witnesses in support, and I want to thank them for still being here after a very long day. I have Michelle Brown.
I'm sure they've been fascinated by the discussion.
Yeah, it was a real education for both of them, I'm quite sure. I've got Michelle Brown and then Vanessa Kirker-Wright.
Thank you, Senator Morlock. Witnesses?
Good evening, Madam Chair and members of the committee. Thank you for having us here. My name is Michelle Brown, and I'm a certified family law specialist. I practice out of San Diego, and I'm with the Association of Certified Family Law Specialists, who are comprised of about 650 certified family law specialists across the state. When the marriage of Davis came down in 2015, it extracted a significant amount of chaos across the entire family law community. The listservs lit up like a balloon because what were we going to do with the practical effects of this? The SB 1255 is very important legislation, and it helps the practicalities of life as to what occurs in everyday life. As the senator explained, in today's society, for medium, moderate, low-income families, they cannot afford two residences. It's just not practical. This affects your people who don't have the ability to move out and maintain separate residences during a divorce. The division of the assets and the liabilities does not happen until the conclusion of the case in either settlement or trial. So during the pendency of the proceedings, the parents don't have any idea who's going to be awarded what asset. If you have a bright line rule, as what has happened in Marriage of Davis, it requires the parties to move out. What SB 1255 does is allows that to be a factor. It doesn't preclude it. In looking at the analysis, they brought up the fact that there is a footnote 7 in the case that says, well, Marriage of Davis doesn't necessarily preclude the fact that you don't have to live separate and apart. But the reality of that is that would be a rare case. There is a presumption that you have to live separate and apart. And as a practitioner, I can tell you that what has happened is when clients come into our offices, we are telling them, you have to move out. I know it's going to hurt your family. I know you might not be able to afford the mortgage. I have a case where a house went into foreclosure because the party had to move out in order to preserve the date of separation. It's not fair to families. The other item that I wanted to address in the analysis is with regards to the periods of separation. There was a concern that maybe if there wasn't a bright line rule that it would hurt 4336 on the periods of separation. We disagree with that because the bright line rule that is enacted in Davis actually does hurt the periods of separation, because if you're the spouse who moved out, and you have two parties who are attending marriage counseling, they're trying to reconcile, but they've moved out, that spouse is going to say, no, Marriage of Davis says my earlier date, that's my move-out date. SB 1255 allows the court to look at everything. Look at the move-out date. Look at the fact that you've gone to marriage counseling. Maybe you've gone on dates. We urge your aye vote on SB 1255, and I'm happy to answer any questions.
Thank you. Thank you.
Good evening, Madam Chair. Thank you.
Good evening.
Thank the committee for this opportunity. My name is Vanessa Kirker-Wright. I have a hoarse voice. My apologies. It was hoarse when I arrived earlier today. I am the chair of Flexcom, and we are in support. We have taken a support position on 1255. It is my piece of this presentation to address the concern that abrogation of Davis and Norville will harm the poorer spouse more than it will help. Was one of the issues in the analysis. In fact, what we have found is this, and I'm going to use a couple of practical examples. If separate residence rule stands, the richer spouse, the one who wants to preserve and protect the separate property assets, will move out, is more likely to move out of the marital residence, leaving the poorer spouse to figure out one of three things: how to pay the mortgage, how to put, pay the utilities, keep the lights on, put food on the table, or to move out him or herself, or, and if they move out, it's real likely that the richer spouse will move back in, or to let the house go into foreclosure, thereby devastating the entire community. You might ask yourself, well, wouldn't the richer spouse save that house from foreclosure? And the likelihood is 50-50. What I've seen is if you're angry enough at your spouse to move out to preserve your separate assets, you're angry enough to let it go into foreclosure, thereby affecting your family. Even if, minor children, they don't have any consistency or stability. So that's what happens with a bright line rule, whereby you elevate any single objective fact over the other objective facts that a court can use to determine date of separation. They're all important. It is therefore not true that Davis protects a financially vulnerable spouse. In fact, the opposite is true. As a matter of fact, right now, a colleague is in trial in LA on the following facts. Husband and wife separate, but stay in the same house until it's sold. Wife could not move without the sales proceeds. When the house sold, she moved. While they were still living together, husband incurred $400,000 of debt. He is now invoking the Davis date of separation rule for purposes of characterization. So that bright line rule can be manipulated. Anyone can game the system unless the system understands it can be gamed. And when you give a judge the opportunity, a family court judge, the opportunity to consider all of the objective evidence with regard to date of separation, it's less likely the system will be gamed. Family law proceedings are largely fact-based. Elevation of that one single objective fact over others will result in inequities that the family law court would not be able to cure. The Davis Court's reliance on what it meant to be, furthermore, the Davis Court's reliance on what it meant to be separate and apart in 1870 or 1970 or 2002 is very different than what it means today, and it didn't contemplate the realities of middle-class Californians in 2016. I leave for you the thought that when the date of separation is disputed, the family law court must be able to consider all of the factors to come to an equitable decision that protects the family from the cynicism of manipulation. SB 1255 permits the family court that discretion. The bright line rule in Davis does not. I urge your aye vote.
Thank you. Other witnesses in support? Are there any witnesses in opposition? Come forward. In support, I'm sorry.
Sorry, Your Honor. This is David Lederman.
I like the sound of that. Sorry, Your Honor. No, I'm just,
I'm trained.
well
The
done.
Association of Family and Conciliation Courts, we support AB 1255, and I concur with the statements made by my colleagues, Ms. Brown and Ms. Wright.
Thank you.
Thank you.
Any other witnesses in support? Are there any witnesses in opposition? All right, we'll bring it back to the members. Senator Leno, would you like to start off the discussion?
Senator Morlock, I clearly see that your intent is to benefit families here. And I'm more than likely to support the bill today. And I know that there's no perfect situation and that you're trying to prevent manipulation of a less resourceful partner in this dissolving marriage than the one who has more. Is it not possible, though, if we do just leave it to the discretion of the court, that the spouse with the resources will likely be able to get an attorney, and it's a potential situation that the one without won't, and that there could be some manipulation of what's presented to the court? Is that just an outlier possibility, or how do we deal with that situation?
Well, I would start by saying that you and I share a burden for the poor in our state. We agree on the factors on poverty. As someone who's practiced in CPA world, the biggest cause of divorce usually happens to be the finances. That's the number one cause for husband and wife dissolving their marriage. And so both usually do get legal counsel. So in that regard, maybe I could have one of my witnesses give the legal perspective to answer your question.
I actually think SB 1255 is better than for the gaming of the system, because when you have marriage of Davis, that it is a bright line rule. There is a presumption that if you move out, you are not separate if you don't move out. A spouse maybe who is able to obtain counsel goes into an attorney and is able to ascertain, oh, if I move out, then I've established a Davis rule. The spouse who isn't able to have an attorney, who doesn't understand that he or she may be sending love notes, maybe going to marriage counseling and thinking that they're truly working on it, because it often happens. We're humans. People have marital problems. You move out and separate with really no intention of getting a divorce. But that higher earner who knows, well, I can use this as a move-out date and potentially manipulate the other person. With this bill, the court looks at everything, and that move-out is only one factor, not the factor. That is why we believe that you have the court's discretion. They look at everything. They can look at the fact that, well, gee, higher earner moved out, but my gosh, he was or she was leading the other spouse on and sending love letters and going out to dinner. They're going to find that later date of separation, despite the move-out date. Does that answer your question?
I guess my concern is that the lower wage earner, lower wage spouse might not even, and possibly less sophisticated, may not even have an attorney in that courtroom?
Unfortunately, we are around 85% of self-represented litigants in family law. So the likelihood that one or both don't have an attorney is extremely high.
And less likely to have an attorney if one of them had to move out, and that they're not even continuing to share expenses, I would think.
That was my only concern, so an unintended consequence, but otherwise I'm in support of the bill.
Ms.
If I
Kirker?
may, I had a thought, and I'm going to try and express here, which is that when one of the litigants is not represented and the other one is in a courtroom, I'm sure I'm going to speak to all the lawyers in the room when I say that a judge is, even though we have an adversarial system, a judge is generally more likely to be investigative and make sure that what the evidence that is presented in that case is thorough. So I would be much more comfortable in that instance that all of the factors were explored than I would probably if both sides were represented.
That is generally true. Trying to protect the pro per litigant. Yes, Senator Anderson.
I just want to thank the senator for bringing this forward. You know, when I'm thinking about children and family moving out and what it does to the kids, and then losing the property, which may be the only equity that they have in this world that they would have for their children, perhaps to go to college, or perhaps as a down payment towards the apartment that they eventually may have to move towards. To me, this makes a heck of a lot of sense if you're putting kids first in that marriage. And now, I get it that if there's no kids involved, you have a little more flexibility, but once you add those children, I think that anything that helps preserve the wealth of the family so that as they split, the children don't suffer, I think that's a good thing. And with that, I'd like to move the bill.
Okay. All right, any other debate or discussion on this? All right, well, I want to put in my 2 cents worth as someone who practiced in this area of law for way too long, that I also agree that the Supreme Court decision just ignores the reality of life, and particularly today's world, and the desire that people frequently have to do what's in the best interest of their children. Sometimes just the family finances are such they just don't have a choice. And I think the notion that we're not protecting the lower income or the less informed spouse and thus need this clear rule, I think is actually totally wrong. I don't know how to say that otherwise. And I think if you've practiced in this area, you realize that there is manipulation. There's no question about it. When one spouse is better informed, has access to lawyers, sometimes for whatever reason may have a deal closing, they want to get out of the house quickly so they can claim that it's separate property or whatever it may be. That is humanity. I mean, human beings have these failings and are frequently very creative when it comes to their own self-interest, and also can have such intense enmity towards the other spouse that they will do things that can undermine their own well-being. And I think that's why we have a court system. And I think that it is incumbent upon the judges to be able to ascertain, through examination or declarations, just what the date of separation is. And to have a bright line, I think, just really is unrealistic, and I don't think does justice to what goes on in the world today. And so I also want to thank you for bringing this bill. I do believe, however, that we need to continue working to come up with solutions that allows parties to proactively separate. I think there's still work to be done on this bill, and see if we can't find a way to avoid some of the litigation that exists over data separation. For example, if parties divide their income, divide their bank accounts, they each get a checking account, or they start depositing their income into their own accounts. These are things that I think can also be an indication of an intention to separate that should be considered by the courts and are things that, frankly, I think people should know about. In discussing this bill, it's inspiring me to bring back a bill that I've tried now 3 times over the course of the last 15 years. That is a bill that will provide that when parties go to get their wedding licenses, they're given a booklet that talks about what it means to get married. It's a contract in California. It creates certain rights and responsibilities and expectations. And wouldn't it be a good thing if people actually knew what it meant, what that contract means? Because marriages always end. They either end in death or divorce. And when you think about that, people really don't know what that means. And so the ignorance, the lack of information, I think, is part of what the problem is here. And to set this arbitrary, bright line, which doesn't reflect reality in today's world, I think does a disservice. And so with that, do we have a motion? Any other comments? You've moved the bill. Senator Morlock, I hope I gave your closing for you.
You did.
Oh, okay, great.
Madam Chair, you know, you always wonder what it's going to be like to be a legislator, but this was brought to me by some very concerned people, and so it was a real fun exercise for my office as I'm in my first season of presenting bills. I also want to thank you and your office for your guidance and assistance on this. I will close by asking for an aye vote, but I could read like one letter from one mother who's saying, we're still in the same house, we're putting our kids through college, and we're in separate rooms, but so life is complex, and I think this bill will be a real help to a lot of people going through a very difficult situation, and I request an aye vote.
Thank you, Senator Morlock. All right, the motion is due pass to the Senate floor. Please call the roll.
The motion is due pass as amended to the Senate floor. Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Aye. Anderson, aye. Hertzberg? Leno? Leno, aye. Monning? Aye. Monning, aye. Wachowski? Aye. Wachowski, aye.
All right, 6-0, that bill is out. Thank you. And thank your witnesses for